Hello, good evening, and a very warm welcome to our weekly current affairs of law again. I am Jyotpreet, law expert, and we will be discussing the current affairs for the 5th of December to the 12th of December. So just like every time, let us quickly begin with the concept of the important judgments that have come in from the Supreme Court in the past 1 week. So let's quickly begin. First and foremost, court judgments and orders for 5th of December up to the 12th, starting with the very first judgment, that is Akshay Patel versus Reserve Bank of India and others. Now, basically, what has happened in this case is regarding a regulation in respect of an RBI order for banning the PPE kits, that is the personal protective equipment kits. The export of these has been banned for the current time period. Now, one person, he filed a petition in the Supreme Court stating that I have a fundamental right under Article 19(1)(g) of the Constitution, which gives me a fundamental right of freedom of trade, profession, and business. However, please note that over here, the Supreme Court overruled his contention and they have said that the measures adopted by the Reserve Bank of India to implement a ban by the union government on the export of PPE kits in view of COVID-19 pandemic is absolutely valid and must sustain. प्लीज रिमेंबर आर्टिकल 19(1)(g) के ऊपर एक बहुत इंपॉर्टेंट रिस्ट्रिक्शन है, दैट इज आर्टिकल 19 clause 6 gives a reasonable restriction on the aspect of freedom of trade and business. Now, what is this restriction? That is, the state may take up any measures or give any reasonable restrictions wherever the matter is concerned with the interest of general public. जहां पे पब्लिक का इंटरेस्ट इफेक्ट होगा, वहां पे आपका फंडामेंटल फ्रीडम ऑफ योर ट्रेड एंड प्रोफेशन एंड बिजनेस can be restricted, you can be stopped or refrained. This is what was given under this judgment. Moving to the next aspect, we have the judgment of Parveen versus State of Haryana. Now, basically, what has been talked about over here is section 120A of IPC. Now, section 120A of IPC basically defines for us what is criminal conspiracy. अब criminal conspiracy को basically IPC ने कैसे define किया है? They have told us that, or the IPC has laid down that criminal conspiracy is where basically two or more people. So basically two minimum number of people plus more. So जहां पे भी मिनिमम दो लोग आके एक प्लान बनाते हैं, दोनों डिसाइड करते हैं कि हम एक नंबर वन एक इलीगल एक्ट करेंगे या फिर नंबर टू दैट दे विल डू अ लीगल एक्ट बाय इलीगल मींस, ईदर ऑफ दीज विल क्वालिफाई फॉर क्रिमिनल कॉन्स्पिरेसी. अब क्रिमिनल कॉन्स्पिरेसी में हमें ये याद रखना है दैट क्रिमिनल कॉन्स्पिरेसी में merely planning is the concept that becomes punishable. अब 120A में one very critical and important aspect is meeting of minds. Meeting of minds का मतलब होता है where both of the people have understood the same thing in the same sense. So where one communicated to the other communicated to one, दोनों ने बैठ के प्लान किया, दोनों को एक दूसरे का प्लान completely पता था. This is what is known as meeting of minds. Now, under section 120B, this is the basic punishment for criminal conspiracy. 120A define करता है, 120B punishment को बताता है. Now, here in this case, Supreme Court has clearly observed that in the absence of an evidence, कि अगर हम prove नहीं कर सकते कि there was in fact a meeting of minds, then हम section 120B की punishment apply नहीं कर सकते. So it is a very important aspect कि meeting of minds of those two conspirators will be a crucial element. Moving now to the next judgment. Next judgment talks about Rasmita Biswal and others versus DM National Insurance Company and others. Now, basically, this judgment is talking about the creation of motor vehicle appellate tribunals. Naturally, with the expansion of the scope of Motor Vehicles Act, अब जो हमारी recent judgment आई थी Motor Vehicles Act में, that has eventually led to a huge number of cases in the same regard. So what exactly this is about is कि इतनी ज़्यादा pendency of cases आ चुकी है now that now finally the Supreme Court has come out and given a recommendation. And ये recommendation क्या है? That we shall now try to constitute motor vehicle appellate tribunals. मतलब जहां पे motor vehicle act की appeals जा सके वैसा एक tribunal set up करना चाहिए. Now what is a tribunal? Let's quickly talk about that. A tribunal is basically a quasi judicial body. Quasi basically means it's partly judicial. पूरा कोर्ट की तरह नहीं फंक्शन करती है, but it looks into few aspects of the it follows few of the principles, but पूरा जो लंबा प्रोसीजर होता है कोर्ट का वो नहीं फॉलो करती. So here एक ट्रिब्यूनल सेटअप करना चाहते हैं to look into the matters of motor vehicle appeals. Now motor vehicle act से related जो भी cases हैं they should now be set up. And here this is in respect of section 173 of the Motor Vehicle Act. Please remember, there is a power given to the Parliament as well as to the state legislature under Article 323B for the creation of a tribunal for any purpose. So this is something that you must keep in mind in respect of this judgment. Next comes Nivedita Singh versus Dr. Asha Bharti and others. Now, basically, इसमें क्या होता है? Here in this case, a plea is filed in the Consumer Court. अब please ये हमें याद रखना है कि Consumer Protection Act will be applicable in relation of certain complaints where a consumer is affected. ठीक है? तो Consumer Forum में एक complaint file करी गई थी where it was in respect of certain services given by a doctor. But वो जो services थी वो free of charge थी. Now, when we look at section 210 of the Consumer Protection Act, under section 210 of the Consumer Protection Act, services have been defined. Now, please remember certain acts have been recognized as services under the Consumer Protection Act. Wherever there is a free of charge provision given or a service given, उसको हम section 210 of Consumer Protection Act में नहीं गिनेंगे. So what does that mean? अगर free of charge कुछ कर रहा है कोई आपके लिए, then that is not going to come within service under consumer protection. However, in this case, what had happened was that a medical officer, though he had given a service free of charge, but he was getting a certain salary from the hospital. Now, this has been clearly laid down by the Supreme Court that just because a medical officer was getting a salary and provided you a free of charge service, we will not count that service under section 210 of the Consumer Protection Act. Please remember, this means कि इसकी वजह से अब एक plea in respect of such a cause, if it is filed, उसके ऊपर Consumer Protection Act apply नहीं करेगा. This is what was laid down in this judgment. Moving to our next aspect, that is Jacob Punen and others versus United India Insurance Company Limited. Now, with a lot of insurance-based cases that keep coming up in the Supreme Court, उसमें से एक ये case आया. Now, in this case, what has been said was that here कि जब भी एक पॉलिसी कोई भी रिन्यू करेगा, दैट इज एक बारी लेट्स से अ पर्सन टुक अ पॉलिसी फॉर 2 years, उसके बाद अगर कोई भी उसे रिन्यू करना है, ठीक है, तो उस टाइम पे इट इज कंपल्सरी फॉर द इंश्योरेंस एजेंट जो आपको इंश्योरेंस देता है, तो दैट एजेंट नाउ he will now come and clearly say and tell you कि अगर कोई भी change आया है within your policy. So if there have been any changes in the policy, it is mandatory that such changes shall be communicated to the person. Specifically अगर ये person senior citizen है, अगर वो नहीं करता है, then what will happen? Then we will regard this as a deficiency in service. So a deficiency in service naturally would make Consumer Protection Act applicable upon this person. So communication of changes in policy is a mandatory or a compulsory aspect. अगर नहीं किया, इसको हम deficiency in service मानेंगे. Moving ahead, let's talk about the bills and acts in the news in the last 1 week. Now, please remember the situation that has occurred in Nagaland. So, after this very saddening news of how some of the people, civilians, were shot at and killed, in the state of Nagaland, there came an appeal from the state ministers of Nagaland for the repeal of AFSPA, that is AFSPA. AFSPA है क्या? AFSPA is basically the Armed Forces Special Powers Act. Now, please remember, wherever there comes a situation in any state where we feel the environment is turning violent, that there is an unease, or we might like to call this a disturbed area. In this situation, the government has the power to declare the application of ASPA in that state. So this is what actually happened in June 2021, where the Ministry of Home Affairs had actually declared the entire state of Nagaland as a disturbed area and had applied ASPA in this state. अब ASPA के अंदर होता क्या है? Under ASPA, basically what happens is that the control of that state goes into the hands of the army. So what happens? Martial law comes into force. That is, the army takes control of all the aspects of that state. With the army taking control of all the aspects, they can, ban any movement. They can impose curfews. They can even ban gatherings above 3 or 5, gatherings above 5 people. So here, army takes control of the situation. So here, naturally, with the situation that has occurred, Nagaland has now, or the ministers of Nagaland have now come together and have asked for the removal or the repeal of ASPA as a whole. So now let's just quickly talk about disturbed areas. Now, when can a disturbed area be declared? Now, an area can be declared as disturbed due to what? Because of any disputes between the different religions in that area, maybe due to language, regional groups, or castes and communities. So wherever we see that there is a communal violence aspect in that state, that area might be declared as disturbed. So this is what has come up in the case of bills and acts in the past 1 week. Moving ahead, let's talk about your important events, days, and appointments in the past 1 week. Beginning with the former Chief Election Commissioner Sunil Arora has been requested to join the International Institute for Democracy and Electoral Assistance Board. This is also in short known as IDEA. So IDEA. Now, why and what does this organization basically do? Please remember firstly that this is an international body. And what does this international body really do? Please remember that it looks at and it supports the democracies and its values in the world. That is what is the concept behind International Institute for Democracy and Electoral Assistance. Our former Chief Election Commissioner has now been requested to join the board of this international body. Next, we have German parliamentarians have officially elected. Now, talking about an international aspect, we have German parliamentarians have officially elected Social Democrat Olaf Scholz as the new chancellor, ending the 16-year-old regime of Angela Merkel. So we have a new chancellor in Germany. Moving next, we have Chile. The country has now decreed a law allowing the same-sex couples to marry. So basically, what has happened here is same-sex marriages has been legalized in that country. So basically, talking about this aspect in relation of India, if you all remember, in 2018 we had a remarkable judgment come out as a, as a result of our right to privacy judgment. We had another judgment that was known as Navdeep Singh Johar versus Union of India, wherein we had decriminalization of section 377. Now 377 of IPC basically did what? It had criminalized intercourse between people of the same sex. Now with that, naturally section 377, yes, has been banned. Kerala High Court last year had spoken about, and very recently has also talked about banning of sex change therapy. And beyond that, they've also talked about how the government must now come and create and take steps in this regard. However, what we lack today and where our loophole is, we still do not have a law on marriages between people of the same sex. So India is still a step behind. We can hope for it in the future. However, till date, हमारे पास अभी कुछ भी नहीं है. Okay, now moving to the last aspect, we are going to talk about some important days that have come in the past 1 week. That is 9th of December, that is International Anti-Corruption Day. This is our international day that we celebrate. Please remember, we in India also have some laws and legislation in respect of anti-corruption. So first and foremost, we have Prevention of Corruption Act 1988, which was recently amended in the year 2018, deals with aspects of corruption in India. Now, beyond that, we have certain provisions in IPC as well that deal with this aspect, but these are not the only things that deal with corruption in India. We have some more laws, such as we have Foreign Contribution Regulation Act 2010. We have the RTI, that is Right to Information, also contributes in disclosures of any form of corruption. This is now 2005. Next, we have the Prevention of Money Laundering Act 2002. And lastly, if we were to talk about Fugitive Economic Offenders Act, again, that has come in very recently, 2018. So all of these are the various legislations that deal with the aspect of corruption in India. Last but not least, we have 10th of December was the Human Rights Day. Now, if I was to talk about human rights, we know these are those basic set of rights that any individual has, which are crucial and important for each and everyone's development. Now, in India, human rights basically came into our constitution, and they have been reflected in the form of our fundamental rights, which reflect or show to us our civil and political human rights. And on the other end, in our directive principles of state policy, you see or have a view of the social and economic human rights. So these together have compiled, and with the subsequent developments that have happened in the country, बहुत सारे aspects हमने अब human rights के domain में include कर दी हैं with the help of right to life article number 21. So that is all for today. Thank you very much. For more such videos, do subscribe to our channel HitBullsEye. Thank you.